If you were wondering whether or not Blake Lively's letter motion yesterday essentially informing the judge, I need more time because you need to deny this because I said so, because for the motion regarding judgment of pleadings where Wayfair is essentially attempting to dismiss her whole case for the most part. Well, our go-to scorched earth lawyer, Kevin Fritz, returns and he has a knockdown answer to her, which impresses me quite a bit. And he gets right to the point, essentially demolishing her points. Now, of course, we don't know how the judge is going to rule in this case, but he has good foundation for these, and I think he makes a good plea to the court. He states that a party is permitted to move for a judgment on pleadings after the pleadings are closed, and that this is available to challenge a plaintiff's failure to state a claim. It's not waived until the end of trial, so it essentially can be done anytime. As I've explained to you, Ms. Lively mistakenly contends that Wayfair Party waited almost 9 months to file their motion, and that deciding the motion now would merely result in redundant briefing and squandered judicial resources. Recall how I mentioned she conceded that she had changed her complaint? Yeah, they get there first. Her operative complaint was not filed 9 months ago, but 2 months ago after the court had dismissed her suit against Jed Wallace and Street Relations. Ms. Lively was not required to supplement her pleadings, but nevertheless did so by filing her second amended complaint on the 30th of July, 2025. When Ms. Lively decided to supersede her previous pleadings with the filing of the Second Amendment complaint on the 30th of July, she was aware that Wayfair parties were not required to file answers for a few weeks thereafter, and that upon such filings and only upon such filings, the Wayfair and parties were entitled to seek a judgment on pleadings. Correct, so you have to respond to it before you can do judgment on pleadings. In fact, Ms. Lively acknowledges at a July 30th hearing in a related matter, the Wayfair parties informed the court that they will consider relief under Rule 12c. If Ms. Lively is now not ready to oppose the motion, her fault is to blame. There was some controversy over the CRD because she indicated that she revised it, and there's a gigantic issue with that footnote. They don't even address it because it really doesn't matter. According to federal law, in order to sue under Title VII, she needs an EEOC right to sue notice. Blake's complaint doesn't attach any of her CRD documents. In order to sue in court, her complaint must allege either the date on which she filed her California CRD in order to ensure that it's timely, and it must have a copy of it so that the judge can confirm that the people that are on the right to sue notice are the same parties that she's suing. She didn't either. In her initial complaint that was filed according to the December 20th, 2024, she listed it ends with us movie with no right to sue them. She did not include a copy of her CRD complaint, and she did not even copy a federal right to sue notice. She cannot amend it afterwards without notice to the court and obtain leave to amend to include the parties. She improperly included an ends with us movie from the start, and changing it now doesn't change the fact that she didn't exhaust her administrative remedies. I got that all from the CRD. So he tells the court that this a judgment on pleading is appropriate, where inferences drawn in favor of the non-moving party. The non-moving party has failed to allege facts that would give rise to a plausible claim or defense. Here, the motion seeks dismissal based purely on predominantly legal issues. Okay, they claim that their legal problems are her sexual harassment, retaliation, failure to supervise, and aiding and abetting claims under California codes fail for absence of extraterritorial application. And if you visit the CRD, you'll receive a letter stating that you have a right to sue, which entitles you to sue in the state of California. Or if you go to federal court in California, you have to get a federal right to sue. That letter of her right to sue did not give her permission to sue California claims in New York. Blake in her motion tried to tie it together by saying, I have federal claims, that's why I'm here. And then I have California claims that arise from the same issue. So you have jurisdiction over them. That is not sufficient of an argument of jurisdiction. They further contend that she failed to exhaust her administrative remedies regarding numerous claims against it ends with us movie. She failed to properly plead retaliation. Ms. Lively's defamation claims are excluded by litigation and/or fair reporting privileges, and she failed to state an underlying tort to support her civil conspiracy claims. None of those issues require the court to examine anything other than her second amended complaint and the materials incorporated therein by reference or integral thereto. She does not specify how any of the voluminous evidence that she has uncovered would be properly considered in an opposition to the motion or warrant the denial thereof. Stated differently, there is no necessity for Ms. Lively to rush to gather proof from a still ongoing discovery in order to resist the motion, since the motion is on the face of her own pleadings. While Miss Lively indicates that she may still further amend her pleadings, she fails to state why she has not amended her pleadings and why the court should permit any such amendment at this point in the litigation. She has already been given a second chance. Actually, a third, because she filed her first complaint. Then her first amended complaint. Then her second amended complaint. Which I said, like, you can't infinitely keep amending your complaint. That's not how it works. And it wouldn't change the fact that the FEA claims can't be brought to federal court. She's in the wrong court. If the motion is granted in full or in part, any such adjudication will reduce the number of Miss Lively's claims. In turn, and even assuming any part subsequently seeks summary judgment, the case will have been properly streamlined, thereby reducing the amount of briefing and evidentiary submissions on any motion. Thus, judicial forces will be preserved. The very purpose of a Rule 12c motion. So, if the judge can rule on the motion on pleadings, judgment on pleadings before even summary judgment happens, they don't even have to file a summary judgment is what they're saying, if it's not even needed. And then he proceeds to the point that she cannot elucidate that the motion will postpone the trial set to begin in March of 26. He reminds them about the ongoing fact discovery. There is no summary judgments that have been filed, and the trial is over 5 months away. He even gives examples of the courts having granted Motion 12c at procedural points much farther down the line and ahead than where they currently stand. Some have even granted it after motions for summary judgment are made, and even after partial summary judgments are awarded. I adore the fact that she needs an extension of time because how many times did we have to tell her that she had moved for sanctions and filed all of these papers while discovery was still ongoing, and whenever Wayfair attempted to ask for an extension, she would not acquiesce to it. He points out that she and her husband have filed numerous motions for sanctions against the Wayfair parties and their counsel, and that all of this happened while discovery was ongoing, right? Well, so she filed so many extra motions against them, so they have to answer all those. And they were still in discovery, and now she is trying to say that she can't answer this because she is in discovery. He also notes that granting it would mean that the parties had to brief the motion close in time to the summary judgment deadline, when the court would yet to have a chance to narrow the case. The request should be denied. Then, he brings a request of amending the case management plan and the scheduling order. And he said that it's because when the judge first modified the schedule of orders on September 9th, he modified the expert discovery schedule to ensure that discovery could be completed on November 14th. But they did not pose to, and the court did not approve an adjournment of the current November 5th, 25 deadline for summary judgment. So you are supposed to do summary judgment once all of the discovery is closed. You don't do a summary judgment while discovery is ongoing. And so what he's saying is that you have a date for us to finish these by the time we're still doing expert discovery. He said fact discovery is not expected to be completed by until October 10th. Last night, Wayfair parties proposed revising the case management plan and scheduling order, and they're waiting from Lively to respond. But they are saying that opening reports for the experts would be October 24th. The deadline to exchange expert rebuttal reports would be November 7th, and then deadline to complete depositions of experts would be December 1st and December 15th, 25 deadline to file summary judgment motions. They mention that adequate cause is required for this as it will leave the court with enough time to dispose of the motion. Provide the parties with the opportunity to complete fact discovery before the exchange of opening expert reports, and permit the parties to complete expert discovery before summary judgment motions are filed. Notably, if most of her claims are rejected through the motion, the suggested schedule will permit the court and the parties to concentrate on a few outstanding claims in relation to any summary judgment motions or trial. How, moreover, on September 30th, merely 10 days before the current October 10th deadline for opening expert reports, preferred a new theory of damages, Miss Lively's alleged lost profits computation, and then they share some if information, so she changed at the deadline how she was going to claim damages. And they say now their experts need more time to examine that claim. As long as the trial remains for March 9th, I don't know why this isn't amenable. And I've told you a million times how tight all of this is. And you cannot file for summary judgment if discovery is still open. So I don't see why this wouldn't be amenable. The only thing I can see is that Blake will not agree for whatever reason, but this benefits everyone. And they also say, this is funny, the request for admit. So you have to, before you do summary judgments and before you get to trial, you have to settle and agree what the facts are of the case. And so you have to get people to admit certain statements. And according to Kevin, the requests would be and are supposed to be served by August 14th. In the parties' joint request to revive part of the scheduling order, no request was made to extend the deadline and no extension was ordered. Months after learning the deadline and 6 weeks after the deadline has passed, she seeks to extend the expired deadline. But Miss Lively does not state why she was not required to serve requests to admit by deadline, or why the fact that future depositions existed kept her from serving requests, particularly since requests to admit are supposed to limit factual issues. So he wishes for her to be denied for lack of showing good cause for the suggested amendment. It's crazy she missed a deadline. Consider all the times that Blake has come to this court and informed them that Wayfair is behind schedule. They're stonewalling that they haven't delivered materials. And here we learn that she was to deliver her request for admission on August 14th and did not. Then she requests relief afterwards. You know, she's got lots of very high-powered lawyers, and I don't believe they have client control here. And I also don't believe that they're being truthful to her. I cannot believe that an attorney who is a seasoned attorney in employment law and litigation would even contemplate filing her case without the proper right to sue by the federal government, without including with the complaint a right to sue notice. And incidentally, up until this point, Blake Lively has never provided a letter to court in order to demonstrate she has a right to sue. All Wayfair has to do is show the court that when she initially filed this lawsuit, it ends with US movie was not included in the right to sue. And once you sue based on the right to sue notice you get, that's your chance, right? Amending it and adding someone after the fact doesn't cure the issue because the claims were made off the right to sue. And that litigation you started, you told the court was based off that. And if you've effed that part up, you don't get to run back and say, oh, just kidding. And if you do change it, you have to tell the employer. The California right to sue letter states that it's your requirement to serve notice on the employer. So, if she cured it and got a new right to sue, she was supposed to tell Wayfair and she was supposed to tell the court, but she didn't, which is why Wayfair is ignoring that part of it. And I've been saying all along these charges were dead on arrival since the day she made this charge because of the way she botched the steps with the CRD and the EOC. And I don't know at what point they're going to raise the EOC issue. Maybe Blake hasn't even informed them that she is entitled to file a suit as it is granted by the EEOC as well. Because if the EEOC hasn't provided her with a right to sue and she is filing this lawsuit at present, and for record, her present letter for California tells her that she is required to file an EEOC charge herself. It says that she should acquire that. She did not do a cross-complaint or dual filing, which she can, but she did not. And her right to sue statement says, if you're going to go federal, you have to go to the EEOC within 30 days of this letter or 300 days from the last moment of sexual harassment. She never went to the EEOC because she knew she couldn't, because the last reported incident she claims was in May of 23, and she was well past the 300 days at that point. She's been time-barred from the beginning, and she's just mad that they're now getting rid of this, and they've known this the whole time, right? And even if they sat on it the whole time, they didn't have time to do this until she again decided to amend her complaint. It's so dumb. And they could have waited to do it after her second amended complaint, simply because after August of 2024, more than 300 days has passed since she claims any retaliation happens. And they're in the clear. So they could have just waited strategically too. But she's the one again that chose to amend her second amended complaint. So basically what Wayfair is saying to the judge is that all of these problems that she's bringing you are her own self-inflicted choices. It's her fault everything is scrambling at this point in time because she chose to do her second amended complaint in August. I figured out that we were going to react. We informed her that we could file this, and now she's complaining to you. I sincerely hope the judge gets it correct and doesn't care about talking down to them, but there is a hearing on tomorrow regarding this specific issue. So I am going to sit in and will let you know and get back to you once this is done. He is not going to make any sort of ruling at the hearing. He's going to take it under advisement, so tell me what you all think in your comments below and let me know. Make sure you give this video a thumbs up. Don't forget to subscribe to my channel if you are not already a subscriber and press that bell so you can never miss a video. Thanks ever so much for watching.